Not very loud, is it?
It's a bit quiet. Little bit. A little bit quiet.
Quite quiet.
A little bit quiet, yeah, but I can still hear you.
Okay, so it's not quite any setting. Okay. Still manual. Okay. Okay, now this one is working this time. Okay, now okay, still able to show. Okay, now well, what was our topic last time? Pleadings, right? Everything about pleadings. So plaintiff's first pleading is, thank you, enter. How about the rest? Are we in yet? Are we here? Okay, so first pleading by the plaintiff.
Statement of claim.
Statement of claim, agree. The next pleading is by the defendant and is the
Defense.
or
Counterclaim.
defense or defense and counterclaim. So assuming there is a counterclaim, so the next round by the plaintiff is the
Reply.
yes, reply and defense to counterclaim because it's against the counterclaim. Okay, so is that all? What else can there be? Rejoinder by the defendant and surrejoinder by the plaintiff. Notice that ultimately the plaintiff still has the last say, right? But are those okay? Which pleadings are mandatory? Statement of claim, without which there is no claim. Okay, and is the reply mandatory? No, reply is not mandatory. Rejoinder? Not mandatory, surrejoinder. What about rejoinder and surrejoinder? If you want to file and serve a rejoinder or surrejoinder, what do you need to do? You need leave of the court. Now, okay, one more question. Is that all? Are those all the pleading, all documents that can be called pleadings? Of course, my question is tricky. Is that all? What else? Okay, you can still have requests for further and better particulars and answers to requests for further and better particulars. Okay, so we all get that. So we have statement of claim, allegations, supposedly one allegation in each paragraph. For in the defense, what three choices do you have for each allegation? Admit, not admit, and denial. Okay, what is admit for? If you
Agree.
agree to the allegation, yes, I didn't pay. Okay, nothing else further need to be said, although you can still say something further. Not admit, meaning you don't want to agree. That's not admit, right? You're not agreeing, but you can't say anything else. Most likely because you don't know any information to rebut that allegation, to counter that allegation. So you just say, I'm staying silent, but hey, here I am, I'm not agreeing. I just make sure that you know that I'm not agreeing. You go and prove it, right? Remember the inspection at Tommy Construction's factory when Mary wasn't there, so she can't say anything to rebut the fact that there was an inspection, right? So Mary stay put and say, you go prove it. Okay? Denial, disagree, and I have something to say. Okay, I have my own version, my version of positive case to say. Okay, good. Now, Just making sure that have they recording yet? I can't see. Okay, I can. Okay. Now let's get to service. What are we doing? Okay, let's get on the topic of service. Tonight we're looking at, okay, we have all this service of legal proceedings. Now, of course, the writ is the very first document that you would serve, right? With or without the SOC. Okay, with SOC is a specifically endorsed writ, right? Remember SNS, okay? With the S is, I might have to remember it, okay? Specifically endorsed writ is the one with the SOC. The other one is generally endorsed writ. Okay, so how do we serve? Now, why are we devoting almost one whole topic on service? Now, if you don't comply with service, your application, and any order you seek or you've obtained based on that application any orders or judgments you get based on those applications may collapse. Okay, because it's very important requirement. Service refers to the delivery of legal papers, legal documents upon another party. It's to ensure the other side served, the parties that's supposed to be served the documents, has knowledge of the existence and be kept up to date on the progress of the legal proceedings. Non-compliance with the relevant rules would result in, or the service itself would be called defective or invalid. Any orders or judgments that you get from that application based on those papers, the other party who was not served properly can apply for that order or judgment to be set aside. Okay? Cancelled, put away. Okay? Set aside, cancelled. Now, it makes sense. Let's say the first document being the writ. Okay, who's my unfortunate victim tonight? Okay, Alice, yes. Alice, let's find someone from the back. Okay, I remember Hilda's name. Okay, Alice and Hilda. Okay, let's say I'm suing Hilda. Okay, Alice, I'm third party independent. So Alice is suing Hilda. Alice prepared the writ, prepared the SOC, the whole pack is ready with all those Form 14, Form 16, whatever. So Alice is supposed to serve the whole pack to Hilda. Well, if the service was not done properly for whatever reason, and Hilda actually doesn't know, never got to know that there is this action or claim against her. And without her knowing, a judgment's actually been ordered or granted from the court. Is that fair? You're sued, you don't know you're being sued, and then without you knowing, there's actually a judgment entered or some sort of adverse order against you. Not fair, right? You should at least know that someone's coming up to you, right? Okay, so that's commencement of the action. Now, what about if you have, we talk about inter partes a lot, right? Inter partes application. So let's say the other side is trying to seek to amend a SOC, okay? So Alice changed her mind. There's some other details she wants to add in the statement of claim, so she applied to amend the statement of claim. She didn't serve for some reason, she didn't serve on Hilda properly. Hilda didn't know that the SOC has been amended. So her defense would not respond to Alice's amended SOC properly, right? Perhaps the paragraph numbers has changed, right? Perhaps the contents change, allegations different. So Hilda would be responding in the defense, would be responding to the wrong content, to the wrong version. Then it's again not fair, right? So when served, okay, getting back to the basics, remember originating process, which means either your writ or OS. Okay, when you serve the writ, for example, it should be sealed with the seal of the High Court if it's a High Court action, or the District Court seal if it's a District Court action. It must be sealed. That's how it gets issued, right? Sealed with the seal of the High Court or District Court before service, because it's then issued, and after issuance, it should be served within 12 months, right? We knew that from last time. We also said that the writ has to be accompanied by a AS, Acknowledgement of Service of Writ of Summons. That's the full name of it, right? For a writ action, that's Form 14. For a originating summons, it's Form 15. Let's, for the moment, just stick with the writ, so it's a Form 14 AS. A form admitting the claim, which would be either one, okay? Either Form 16 for liquidated claim, or Form 16C if the claim is unliquidated. What's the key word again? Whether it's liquidated or not. That the amount is ascertainable. Not that the amount is fixed, the amount is ascertainable. It's calculated based on the agreement between two parties before the action arose, remember? 14 days within which the defendant can complete and return the acknowledgement of service. Okay, that we know from last time already, service of the writ. Okay, no, service is different. Order 10, Rule 1. For OS, is governed by Order 10, Rule 5. That's about service. Order 10 is about service. Now, okay, you want to make sure the other party gets the documents that you're serving. How? First and most preferred method, the best method, is by personal service. It's effected by delivering a sealed copy of the originating process together with whatever you need to, right? Those Form 14, Form 16, right? But the sealed copy of the originating process personally on the defendant. Okay, so if defendant refuses to take the document, you can leave the document as near as possible within that defendant's possession and control. Okay, so Hilda, sorry. Okay, so Hilda, if I effect personal service on you, why is it the best? Why do you think it's the best? Compared to postal, if you send it by post, etc. If I hand it to her, I know she got it, right? I personally know she got it. Okay, so that's why it's the most preferred method. Service is effective on the date on which the originating process is served personally. Now remember the timeline. Now 14 days, 28 days, whatever, right? The time ticking. Remember the tables we looked at last time? Okay, counting 28 days, counting 14 days, etc. Now why? Well, you would say, so what is that date? It's when the service is effective. And how is the service effective, or which is the effective date of service, depends on which method you're using. If I hand it to Simon personally, then we know that day he got it. Right? So that's why the date I serve on him is the effective date under personal service. Okay. Now, what other methods? Postal service is also allowed under Order 10, Rule 1(2). Postal service is effected either by sending by registered post. Okay, registered post to the defendant's last known or usual address in the jurisdiction, or by inserting into the letterbox of the defendant's last known or usual address in a sealed envelope addressed to the defendant. Every word counts. Okay, so it must be last known or usual address, sealed envelope addressed to that defendant. Now, date of service is deemed to be the 7th day after the writ is posted or inserted into the letterbox, unless the contrary is shown. Okay. Now, common sense would tell you that the defendant may get it on different days, right? Depending on which option under postal service you're effecting it by. So if you send it by registered post to the last known address, it may still take 1 day, 2 days-ish, right? If in Hong Kong. Whereas here, it'll probably be in the letterbox the same day, right? That day, you're inserting it. Well, but that's the rule. Just follow that. That's how you count it. Although in reality, it would probably be, the actual day that it gets into that letterbox would probably be different. Still on postal service. Now, for postal service, service is not effective if the plaintiff knows the defendant is no longer living there at the address it's posted to, or by registered post or inserting letterbox. That's okay. So if the plaintiff actually knows the defendant doesn't live there anymore, or there's evidence that the service is not effective to bring notice of the proceedings to the defendant. Okay. The defendant must be in the jurisdiction at the time of service and must have actual knowledge of the writ. That's by the case of Deng Minghui trading as. That means trading as, by the way. TA means trading as. Trading as Tianyi Industrial Company and Chao Shuk Ling Yilei. Okay, quite a long name. Now, the defendant must be in the jurisdiction. All this service is not effective. All this is only applicable to postal service. Why is that? What did I just say? For personal service, I know the defendant got it, right? Because it's personally served on to him or her. Here, we don't know, right? We don't have actual evidence that, yes, he got it or she got it. So, if later on it transpires that, no, the defendant actually didn't get it, wasn't served properly, he no longer lives there, or he's been overseas during the time of service, service would not be effective. Okay? And sometimes that would be the basis of what we call defective service, invalid service, etc., improper service. Now, for substituted service, you will hear sometimes that substituted service, what is it? Okay, it's applicable where it is impossible or impracticable to serve the writ to the defendant. By the way, I stress every time, right? I don't read it all out because you all can read numbers, but you have to cite the rules. Yes, all of them. Okay, so I'm just not reading Rules of High Court Order 65 and Rule 4 and Practice Direction 10.1. It's driving you to sleep, but yes, you need to cite them. Okay? So, substituted service is applicable where it is impossible or impracticable to serve the writ to the defendant. Now, there can be many various reasons. So, the whole purpose of substituted service is to take other steps, alternative steps, that have a reasonable probability of bringing the action or the the action or the writ to the defendant's attention. We'll talk about examples later. It's an ex parte application supported by an affirmation. There's duty, as with any wiki, any ex parte application, any party, whether it's a plaintiff or defendant, making any ex parte application has the duty of full and frank disclosure. So even if I don't tell you about this line, anytime, every time, and anytime you see an ex parte application, the applicant has a duty of full and frank disclosure. Directions will be given by the court as to what mode of substituted service the plaintiff should adopt. Most of the times, the plaintiff would suggest or propose some directions for the court to agree. Okay, getting back here. Now, why do we sometimes need substituted service? Okay, if we are using personal service, okay, if we're using the mode of personal service, most likely the plaintiff knows the whereabout, right? Knows the whereabout of the defendant. Because if you can find him, of course you know where he is. Maybe not, if you don't know where he lives, you know where he works, you can find him, right? If you're using the postal service, you know his last known address or usual address, right? Okay, that's how you can effect it. What if you don't know? What if you actually don't know? What if I'm claiming adverse possession? Let's say I am the squatter, okay, or bade, okay? I occupy the piece of land without owning it. That's what 逆權侵佔 is, right? So I want to get a possessory title by adverse possession. So I want to, but I don't know, perhaps I don't know the owner's name. Okay, maybe I can find the owner's name on the land registry. Right? 可以做土地查下個名係邊個. Right? But after that, I don't know where he lived. I'm already on this land, but the owner never came around for the last 20 years, 30 years maybe. Right? I've never seen the owner. I only know his name from the land search. So how do I serve on him if I want to sue and claim for possessory title? I have to go for substituted service. I have to do before I ask the court to grant me an order for substituted service, I need to show the court that yes, I've tried my best to find and to go for any possible or practicable means to find the defendant. For example, have I asked around the neighborhood? Have I searched the probate registry to see if there's next of kin or any whether he's died, basically, right? Anything else I can trace onto. If there are other avenues, you should not ask for substituted service first. Okay? Sometimes, if there are means to go for disclosure, such as the fraud cases I asked you about, let's say, forget about adverse possession. Let's say it's one of those fraud cases. Can you say you don't know where the defendant lives? If you know his bank account, you can ask the bank to disclose it, right? But you have to go through an application to the court to go for that information. So you haven't exhausted all avenues yet. Okay, if there is any other way for you to find out the address, last known address, usual address, etc., or whereabouts, you should not ask for substituted service. So defendants that you do not know the whereabouts. And other example is for MIPs, or very, very elderly people who may be MIP and living at nursing homes. Okay, if they're under an institutional care, sometimes substituted service may even be that you serve on or through the manager or director of that elderly home. Okay, that's another common scenario. Okay, now getting back to ex parte application. Why would this be an ex parte application? Well, I've already started the action, right? I've issued the writ. I know the name of the defendant. I just don't know where he is. And why is it an ex parte? Think about it. These circumstances. Why is it an ex parte application? First of all, what is an ex parte application? Ex parte meaning one or two? One or all, I should say. One party only before the court. Yes? Well, I'm asking for substituted service, if you think about it. I'm asking for substituted service order because I can't find the other one. Right? How do I get him to come to court? Okay, there's no way. I haven't found him yet, found his whereabouts yet, right? Okay, so of course I can't drag him to court. I don't even know where to serve the document, let alone serve another application to him to get him to come to court. Remember, for inter partes application, you also have to serve those application documents to the other side, right? That's how you get them to come to court, if it's an inter partes application. So it would be an ex parte because I can't find the other one yet, right? I can't find the defendant. Okay, so just a little bit about duty of full and frank disclosure. The reason why that applicant for an ex parte application has that duty of full and frank disclosure is because exactly because it's ex parte. There's only I am in front of the court. So I have a very heavy duty to tell the court all that I know, all information I know surrounding that application. When we have duty of full and frank disclosure, it means I have to disclose to the court anything that is in relation to the application, anything that's favorable to me and unfavorable to me. Okay, it's any ex parte application such as this or injunctions, etc. Right? Because only you are before the court, so you have the duty to be utmost honest and frank. Okay? Otherwise, it would be extremely unfair for the other side because they do not have the opportunity to be heard. Okay, so again, I've already told you that is a very common directions, right? Directions. So substituted service, how? Okay, you've already told me, yes, mode of service, the main mode of service would either be personal service or postal service, yes? So those are the two main types. Substituted service, how? Well, if I can't find their whereabouts, perhaps by advertisements, okay? It's not, well, if I think they are still in Hong Kong, perhaps I will propose to the court that please grant me an order for substituted service to bring it to the attention of the defendant, this action, by advertising in one Chinese newspaper and one English language newspaper in circulation in Hong Kong for 5 days. Something like that. Okay? There are instances if I suspect, in a probate case, that we suspect there may be next of kin in Japan. So we do the advertisement in Japan as well. Okay? It is quite flexible by what method, and I already mentioned to you it may be even be served on the director of the elderly home of an MIP. Okay? Because the whole purpose is to bring it to the attention of the defendant, one way or another. Okay? Whatever has the best hope or probability. If the defendant, if you know the defendant has an acting solicitor for this matter, okay, then you can serve on the defendant's solicitor. In reality, let's say I'm the plaintiff, I'm suing the defendant, I would first check by mail or email or whatever, I would first confirm that that firm, the defendant, that ABC and partners, okay, ABC and partners, that solicitor's firm has what we call instructions to act on behalf of the defendant before we send them the documents or serve on them. Right? Normally they will tell you whether they have instructions to act for that defendant. And the effective date would be when the solicitor, the solicitor's firm normally have a sort of a time stamp, and they may endorse and say received on 1st of March 2021. Okay, so that's your proof of the date of service. Okay, deemed to be served if the solicitor endorses. Normally they have a time chalk and they sign on it, initial on it, or whatever. They have a standard rubber stamp for that. Okay, on the written statement that he accepts service of the writ on behalf of the defendant. Service on persons under disability. Now, Order 80, okay, 80. Order 80 is all about MIPs, mentally incapacitated persons. Service on a person exercising guardianship or care of the disabled person. Normally that's, well, if you have an elderly person with Alzheimer's or otherwise for other reason mentally incapacitated person, or a person in vegetative state, right, in a coma, that can be what happens, right? Service of the company can be by personal service, by leaving the writ with an officer of the company. Now, when we say officer, we don't mean the clerk, or we don't mean the secretary. We normally mean the director. Okay, someone of an officer would be a director would be an officer. A writ may be served at the company's registered or principal office by registered post or by inserting through the letterbox. Okay, so that's similar to postal service, right? Okay, but here it's slightly different. Now, the second part here, by registered post or by inserting through letterbox, that's similar to postal service. The first one is actually leaving the writ and the related documents at the registered or principal office. Now, people like to use registered office. Why? Anyone deals with annual returns and things like that, company documents? Anyone here handles that kind of documents? If you're a company, registered company in Hong Kong, or incorporated in Hong Kong, or registered in Hong Kong, you must have a registered address. So if you think, okay, that's their principal office, you may be wrong, right? They can come back and argue, no, that's not my principal office. But there's only one registered office, right, with the company's registry. Okay, if they are a registered company in Hong Kong under the company's ordinance, they must have a registered address. Okay, that's for writ. The first 2 pointers for writ. Other documents may be served by leaving it at or sending it by post to the registered office. So again, registered office, there's only one. So that's quite convenient, no evasion. What about a partnership? Okay, as in a business partnership. Can be personal service or postal service on one or more of the partners, because they are jointly and severally liable. So if you reach one, it's deemed that you have reached the partnership. Service at the principal place of business within the jurisdiction on any person at the time of service who has control or management of the partnership business. Now, this is probably to cover, remember what you learned about de facto partners, right? If they have, yes, perhaps they're not formally the partner, but they have effectively, they have control or management of the business. Okay. Just to show you what an affirmation of service, because some of you ask me, well, how do we prove it, right? How do we prove we served? I'm the plaintiff. Let's say I served on Hilda. How do I prove it to the court when I apply for some? If I'm applying for some applications, I need to show that I've served the documents. How do I prove it? Well, by affirmation of service. Okay. Remember, whenever you do those, either when you do the statement of truth for those pleadings, or if you do an affirmation, it's practically like an oath, right? Whether in a religious way or not, it's practically an oath. You're stating that you verify as true. And if you make a false statement, you have very serious consequences. So an affirmation is quite serious. And this is an example or sample affirmation of service. Now I will go through the heading, you know that. Nope, okay, that's a summons. Okay. I won't go through the formalities of affirmation. You really do not need those now, yet. Okay, parties. Affirmation of service of whoever is making it. Okay, Peter Wong. Okay, whoever is making or affirming this affirmation. Okay, affirmation of service. The whole purpose is to prove that yes, service has been effected properly. So this is normally the clerk who, paralegal or clerk or a messenger who sent or who served the documents. So Peter Wong, senior clerk or junior clerk of Wong, Lee and Co. Okay, solicitors of the plaintiff, address, affirm, solemnly, truly, and sincerely affirm and say as follows: I did on which date served. I did serve on whichever date the above named. You guys can see, right, at the back. Okay, I did serve on 1st of March 2021 the above named first defendant. This is quite a complicated case because it's got a few counterclaims. Okay, above named first defendant and second defendant with a copy of the following documents under the cover of our firm's letter, dated whatever, by leaving the same, meaning the stack of documents, at its registered office situate at, and then you type the office address. This. Okay, although it's only one document, I think this is a template, as you would appreciate. They do this all the time, so they have a template. So if it's one document, they just list it here. If there's more, 3, 4, whatever. Okay, so that takes care. Tell people, okay, on such a date, I did serve those documents, and I did serve on, let's say another day. So 5th of March 2021, the first defendant with a copy of the following documents. So it's another date. That's why they got to say it chronologically, on which date and on what I served. Okay, consent summons. This one was an inter partes summons. Okay, sometimes it would be with the supporting affirmation as well of the documents. Okay, and then it's an affirmation, proper affirmation format. Blah 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 blah. Okay, back page like normal. That's it. Okay. So it's just saying on oath that by the person who served, I did serve, whether it's by postal service or by personal service. How did it say it served? Okay, so these are all companies. So leaving the same at its registered office, it would be the same. Even if it is by personal service, they will say I did serve on Peter Wong personally. Okay, at whichever address. If it's by postal, or is it by inserting into letterbox, they would say I did serve on the first defendant with a copy of the following documents by inserting the same in the letterbox at whichever address. Okay, so it's pretty similar. Okay, just verifying that it has been done. Okay, so any questions so far? Just up to here. Email? You probably would not try to. No, it wouldn't be. It wouldn't be. And you would want to, because these are all legal stuff, you would want to try to adhere as much as you can. Now, getting into a little bit more complicated. So we've already looked at traditional personal service, postal service, serving on the other side solicitors, and also substituted service, right? How to serve on the company. Now, what if the defendant is actually overseas? It happens, right? So, well, we talked about very, very briefly when we talk about pre-action considerations about forum. Do you still remember what forum means? What does it mean? It means forum. Forum actually means place.
You should go home after the break because I'm going to be recording. Oh, it's okay. I think I'm fine.
No, we're not talking about the discussion forum.
I think I'll be fine after the break or something. Just, oh. It's fine.
When we talk about forum, when we talk about litigation, civil litigation, is where should we sue? Where the court action actually takes place, as in which region or country. Okay, it can mean, okay, when you talk about courts and tribunals, sometimes you hear forum, meaning which court should I sue in. But when we talk about country to country or international law, we're talking about in which country or region should we sue. Now let's take a minute and think about why forum is so important. Alice is suing Hilda. Let's say, like, Alice is based in Hong Kong. Hilda is based in Germany. Okay? Hilda is based in Germany. Alice is suing. Now, if they are very smart and the contract is very large, it's a huge contract worth millions of dollars, they would have been smart, they would have had a very formal contract. It would normally prescribe where, if there's any dispute, how to resolve it. Okay, would it be by mediation, arbitration, whatever. And they would even, in a typical formal contract, they would prescribe if there's any dispute, any action would be can only be commenced in which jurisdiction. Okay, that's similar to forum when you say where you can take the court case. And also you can prescribe which laws are applicable. So is it Hong Kong laws, Germany laws, what? Okay, just like when you do arbitration, you can choose what set of rules. So guess where Alice wants the action to take place? Her business is in Hong Kong. Her company is in Hong Kong. Hilda's company is in Germany, I said. So Alice, where would you like the action to take place?
Hong Kong.
Why?
My company is in Hong Kong.
Right? Her company is in Hong Kong. She doesn't want to go to Germany to sue. That would be very expensive for her. Do you agree? What about Hilda? She wants it in Germany. Not surprising, right? Hilda, would you like it in Germany? Yes. Okay, she agrees with me. So this is quite, sometimes it can be very, people spend a lot of money. If it's going to be a long and difficult court case, people can spend a lot of money and time to first fight on forum. Okay, so if you're arguing before the court, what considerations do you think it would the court? Okay, what factors would the court consider, do you think? Okay, supplier, I would say, just say supplier is in Hong Kong, Hilda is in Germany. How would the court actually, if there's no term in the contract? Okay, of course, the first starting point is where are the parties situated? Yes. From your contract law, do you remember sometimes the court will also think about where was the contract formed? Remember your offer and acceptance, right? when is the contract formed? When is the contract formed? When the offer is
Accepted.
accepted, right? The Big Bang occurs with fireworks. Okay, so when the offer is accepted unconditionally, so remember all this instantaneous communication as well, all these rules and whatnot. So where the parties are, where was the contract formed? Perhaps where the evidence mostly are. Right, that would be key witnesses. Okay, those are some of the common factors the parties would use to argue forum. Okay, so assuming that Alice is on the upper hand in terms of forum, so Alice wants to sue in Hong Kong. Hilda lives in Germany, or Hilda's company, let's say it's a company, okay, let's think this is Alice & Co. and that is Hilda & Co. Okay, both are company. Let's say it's actually a company. So both are corporations. Let's say Alice wants to sue in Hong Kong, but Hilda resides in Germany. To sue Hilda in Germany, we need to serve the legal documents, or the writ, out of jurisdiction. And that mechanism is governed by Order 11. Okay, Rules of High Court, Order 11. It's a very discretionary power to grant leave. It can be by the Court of First Instance or District Court. What do you need to prove to the court? What are the tests, okay, or the criteria to satisfy? You must satisfy the court in order to get approval, leave of the court to serve out of jurisdiction. There's a serious issue to be tried between the parties. Okay, it's a real dispute, and you have a case as well. You have some proper course of action. The plaintiff has a strong, arguable case. Okay, it cannot be a flimsy, shadowy, sort of fishy claim. Okay, and that, because you have to persuade the court. The last one is very discretionary. The court should exercise its discretion in granting leave. This is a catch-all. 守尾門, if you know what I mean, right? Because these two are pretty solid criteria, right? There's a serious issue to be tried. The plaintiff has a strong, arguable case. Third point, the court should exercise its discretion. Well, apart from these two, are there any other factors that the court should consider and persuade the court that in favor of giving you that permission or leave? Okay, so if you ask me, that's any other factors, basically. And the case is Dick & Dick, Pereira Far East Limited. That means in liquidation. The court would exercise this power with great caution. Because the court is saying, okay, the court is deciding, yes, I think Hong Kong is the better forum for you to commence this action and for this action to proceed onwards. Ex parte, the process for applying for an order to serve outside the jurisdiction is by ex parte application, by summons supported by an affirmation. Again, ex parte application, duty of full and frank disclosure. Okay, Mattel Inc. and Tonka Corp. You must always be prepared to argue on the issue of forum non-convenience. Now, while what forum non-convenience is just saying which forum is and, or is it an or? Okay. So it has to be in urgent scenarios only, and you've got leave of the court. Okay, that includes writ, originating summons, petition, notice, judgments, all of this, okay, not to be served on a Sunday. There are some exceptions. some exceptions. Interlocutory injunctions, because it is normally urgent. Execution of orders for committal. Okay, you are trying to arrest somebody basically, right? Have somebody arrested. Defendant is leaving the jurisdiction, again, that's urgent or exceptional or urgency, right? Urgent again. Dissipation of assets, that's similar to injunctions, right? There's some scenario that calls for urgency. Wow, better than high school students. High Court has summer vacation, but not exactly as you think. They still work. Okay, we don't have the month off. Okay, it's just that they will give more room in terms of time. No pleadings shall be served during the summer vacation, but nowadays, a lot of times they ask for leave to do so. You can still do so if you've got leave of the court, okay? And no pleadings shall be served during the summer vacation, and unless otherwise directed, the period of summer vacation, which is the whole month of August, is to be excluded from counting time, the counting of time. Remember your 28 days, 14 days, etc.? The time limits, well, you suddenly get a whole month extension. Okay, excluded for reckoning periods or orders or directions for filing, serving, and amendment of any pleadings. But it only applies to High Court, okay, not for District Court. But as far as I know, many times the parties would actually ask for alternate directions that the time continue to count. Okay. Wow, we're very fast. We're not even half time yet. Okay, so reflection activity. What are the advantages of serving originating process outside of the jurisdiction? Well, it depends on advantages to who, right? Alice would like it to get an order to serve the jurisdiction out to Germany so that the action can stay in Hong Kong. Right? To Hilda, that's bad news. Okay, to be dragged to a litigation that has to be conducted in Hong Kong. So what do you think, apart from what Alice said, what other advantages do you think there are? Bearing in mind that, yes, you do it by summons and affirmation, and here. So bearing in mind, apart from the cost, what else do you think there's advantage to be able to serve the jurisdiction outside of Hong Kong? Any suggestions? Yes, it can help you to expedite or just plot along the litigation. Well, apart from saving costs, Alice can save costs, can also save Alice convenience, right, of not having to go to Germany. Apart from cost, she doesn't want to go to Germany to take the action. What else? Anything else you can think of? No? Yes, it prevents. Well, I'm here to catch you. Okay, and I got you if you're in Germany, come to Hong Kong. Right? Just out of interest, now this is purely additional information. Now for a most other jurisdictions, you can propose directions on how to serve, let's say in Germany or in Singapore or in England or in the US. Okay, I propose to serve it by registered post, or by FedEx, or by personal service on the defendant. Yes, you can do that. For the mainland, you actually have to go through judicial authorities. Okay, just information for those that are related to the legal industry. So if you actually have to sue somebody in the mainland PRC, you actually apply, still under Order 11, but Rule 5A, 5 capital A, as in capital A, right? 5A. And you then have the whole package translated in Chinese. Let's say if you have the SOC in English, translate it into Chinese, a certified copy, together with whatever documents, you would apply, and that the Hong Kong judiciary would actually pass it to mainland judicial authorities, and the mainland judicial authorities would, for a fee, serve it for you. Okay? So for mainland, just be aware that you serve it through the judicial authorities. But that's purely additional information. Okay, so apart from that question, the plaintiff said, let's look at question 2. The plaintiff sent by registered post a sealed copy of a writ of summons to the defendant. Okay, that's the Big Bang time, beginning of the timeline. 2 days later, a sealed copy of the writ was served on the defendant personally. The defendant returned an AS on date 21, which would have been 5 days after the time limit under personal service by registered post. Can the plaintiff insist on the service date by personal service and enter default judgment on day 16? Can they? Right, first of all, it's a registered post. Okay, when is it supposed to be effective? 7 days, yes. Okay, so it will be day 7. Okay, so that would have been the effective date, and 7 plus how many days do they have to return the AS? 14 days within which to return the AS. Right? Now, for personal service, which is what it is here, right? 2 days later. So that's day 2, a sealed copy of the writ was served on the defendant personally. So when was that effective? Personal service, when is the effective date? On the same day, right? Because I served it to you. Okay, so that's on. If you use the same timeline, that's sort of day 2. Defendant, so again 14 days, right? So 2 plus, yes, 14 is 16. The defendant returned an AS on service on day 21. So do you think the defendant was late? Who says late? Now, let's look at the next question is actually exactly the same, on the same vein. It's very similar. Let's look at question 3 also first. Plaintiff served a sealed copy of writ personally. So day 0, 2 days later, the plaintiff sent the defendant a sealed copy of the writ by registered post. So registered post is 7, right? 7 days. 7 plus 14 is 21. The defendant returned the AS on day 23, 9 days after time limit under personal service, relying on the registered post service? Can the plaintiff insist on the service date by personal service and enter default judgment on day 14? So essentially, you see two very similar scenarios. Yes, what do you think? First of all, scenario 2 or question 2. Do you think it's late? Who thinks late? Who thinks not late? Okay. So, in effect, 21. Return it is. What do you say? You think it's? Why do you think it's late? Or why do you think we should? Well, if you think it's late, it means that you think the first one counts, right? The first one is the one that counts. No, actually, it's the second one, isn't it? 7 plus 14, that's 21. Right? That would have been the first effective one. Right? Although that is actually an effective date. Day 2 or day 7. Right? I would tend to say this scenario is not late. Okay? If you count the first registered post. For question 3, so the sealed copy rid of day 0, the first one. I would tend to think that the first effected, not effective date, but effected mode counts. So if you look at that, for question 3, that's personal service. It should be on 21. Okay, personal service 7 plus, no, not 7, 0 plus 7. Yes, I would say that in scenario on under question 3, it would have been late. I think it's safest, the rule to remember is to the first effected mode of service. Okay? 用咗邊一個, which was the first mode used, and stick with that. Okay? We promise not to give this to you in exams, right? It's a bit tricky. In reality, if it has been late because of that, then the court may still be slightly lenient, but as we'll see, depending whether the timeline has been adhered to, it will become regular service or regular judgment or irregular judgment. But that's our next topic. Okay, for default judgment. You notice the word here, default judgment. Right? Default implies that some rules have not been complied with. Yes? Right? Default, by default. Okay? It's done. Something wrong has been done, and that's why I can enter judgment against you. But that's our next topic. Okay, we'll probably start that later today. So question 4, in this chapter we discuss the service of documents on a body corporate. Service of a writ pursuant to Section 827 of the Companies Ordinance, however, is an alternative to service under RHC Order 10, Rule 1. When service is effected through Order 10, Rule 1, then Order 65 becomes relevant. You will note that the two different methods of service may bring about different interpretations as to the date of the service of the writ. The following should be noted. Under Order 10, Rule 1, bracket 3, the effective date would be the 7th day after the date on which the copy was sent or inserted through the letterbox. Under Section 827.
she switched it.
So it actually tells you about service of documents by post. So under Section 8 IGCO, Interpretation of General Clauses Ordinance, service by post is deemed to be effective unless the contrary approved at the time at which the document or notice would be delivered in the ordinary course of post. To avoid uncertainty as to date of service, ordinary post under the relevant rules subject to proof to the contrary have been effected. So it's a presumption. In the case of registered post, the 4th working day after posting for registered post. In case of ordinary post, the 2nd working day. Okay, so it gives an alternative way to count the effective date. So what is our normal postal, by normal post rule, what's the effective date? 7th, right? But here it's actually shorter. So if you want it shorter, then perhaps you can consider ordinary post or registered post method, right? So it has been that it actually attracts some arguments, right? If you want a faster way, you might actually invoke, right, under Section 827, and you say, yes, I'm serving pursuant to Section 827. Okay. So that has always been some source of argument in terms of which is better. Should we go for a break now before we start our next topic? 15 minutes? But do come back in time, otherwise some will be waiting while others are still out. Do you need 15 or 20 minutes? I'd rather let everybody know. What is the consensus? 15 minutes okay or 20? Just one person saying 20. Does that count for everyone? No objections? Because it's up to you whether you want to leave earlier or longer break. It's up to you. How unfair, right? Otherwise specify. I mean acknowledgement of service. Okay, out of goodwill, I've shown you an affirmation of service. We don't use AS for affirmation of service. Do not confuse it. Whenever I say AS in this course, I mean acknowledgement of service. The thing that you have to return within 14 days. Okay, after the writ. Okay, don't confuse it. Affirmation of service, just like any other affirmations, is evidence. Okay, you can use affirmation to give evidence for interlocutory applications. Okay, again, well, I still have I had students asking what is interlocutory again. So after, whenever, just like any other subject, be very awake and aware of the time. Trial, writ issued. Okay, writ issued here. Continuation of time. Anything from here to here can be interlocutory. Am I clear? Since the commencement of the action by the issuance of the writ, this is time 0. Okay, the Big Bang. The Big Bang when the action has been commenced by issuance of the writ or OS. Okay, writ issued, trial. Any applications you make to the court in between are interlocutory. It just means interim. Okay, 中斷申請. Okay, anything between writ and the trial. Are we all clear now? Say so if you're not.
Yes.
Okay? When we have, sometimes I just have to be aware not to bombard you with too much information, especially when they're not examinable, and then I just load it onto you, and then you get worried. Okay, now, okay, when you have interlocutory applications, you have things such as called summons, which you hear a lot, summons, and affirmation or affidavit. They mean the same thing. Again, as I said, this is for your additional information. Now, summons and affirmation are for interlocutory applications. Summons is like the document you are requesting a hearing for. Okay, if you like, I can show you a sample. Okay, but again, that's only additional information. Affirmation or affidavit is evidence. They are actually the same document, just with alternate names. The only difference is affirmation is not religious. Affidavit is. So both is like 好似宣誓，我哋叫宣誓或者叫誓章。Okay? Affidavit is made on oath. This is made by affirming, meaning the person is not a Christian or Catholic, or it's not by an oath. Okay? They're exactly the same thing. Just two names depending whether it's on a religious basis or not. Just the affirming part when the person actually affirms. Okay? Whether they say by Almighty God or but just say I truly affirm. That's all. It's exactly the same. If you have an interlocutory application, the summons is again the document by which you request a hearing or make the application. This affirmation or affidavit, let's keep on calling it affirmation to avoid confusion, because that's what your course manual use. Right? I think your course manual use affirmation, correct? Right? Just forget about affidavit. Okay? So affirmation is evidence in support of interlocutory applications. When you go to the trial, you do not use affirmation. You use what's called witness statements. That's why you hear those names. As long as you 對號入座, right? Put it where it belongs, you won't get confused. Okay? So affirmation supports interlocutory applications. Because interlocutory applications, almost all of them I think, do not have oral testimony. Do not, because it's not the main trial, right? You're only making interim applications. We don't have witnesses and saying, yes, I agree, yes, I did that, I did that. No. Why do we have affirmation of service? Why do we have affirmation saying, oh yes, the defendant has, I believe the defendant has no defense, etc., 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 and these are the reasons. I attach the documents as exhibits. Why? Because there's no oral testimony. The evidence you need must be in the affirmation. Is the format. Okay? Anything still unclear in terms of what affirmation is or summons is? I'll show you, and I've shown you an affirmation. Well, if you use affirmation, this is only one purpose of affirmation of service. Is just one reason that you may make an affirmation. There are millions of reasons why you may want to make an affirmation to support your applications. Okay, we're going to learn some of them during our course. Affirmation of service is the simplest form, right? Because it's the sole and only purpose is to prove. You're trying to prove you have properly served the other side. Okay, To show you a summons, again, please, additional information, just 睇下就算, okay? You do not need it at this level. Okay, but just to show you what I mean by calling the other party to appear before court, basically, or asking the court for a hearing. That's what this is, right? Similar title, blah, blah, blah.
Summons are required.
Notice it's called summons.
Summons are required for a hearing.
Can you see?
Oh, okay.
Right? Notice it's called summons. Here, what I actually have on this side is pursuant, what rule am I asking, what rule is my basis of my application? Here, I think it's an extension of time, Order 3, Rule 5. Order 20 is for amendments of pleadings, remember? We learned about that during pleadings. Amendment of pleadings is under Order 20. Okay, Order 20, Rule 5, I think that means amendment with leave of court. Okay, so summons, summoning someone. This word is singular, okay? If this is a singular, summons. If you have summonses, that's plural form. Okay, so that's why you sometimes see ES if it's plural form. Okay, so summons with an S is actually singular. Let all parties concerned attend before. All parties concerned are these parties, right? The parties in this civil case. Let all parties concerned attend. This is standard wording. Okay, attend before. Now, most interlocutory applications are before masters. Okay, they take care and deal with most interlocutory applications. We try to leave our judges to hear the trials. Okay, that's all. Okay, so with some exceptions, for example, injunctions must be heard or granted by judges. Before master, whoever at the High Court in chambers. Most interlocutory applications are heard by masters in chambers. And that's why if you can't forget the particular application, if you must say before who, where, and where, most interlocutory applications which you are learning are heard by masters in chambers. They're just essentially, in reality, they're just smaller courts. But open to the public, sitting at the High Court, date, time, day of the week, date, time. Okay, standard wording. On the application on the part of the first and second defendants. So this is the applying party for this application. Okay, remember each side can make applications, interlocutory applications. And this one is made by first and second defendants. For an order that, so what directions or order is or are the first and second defendants seeking? This one, I think, yes, here we go. The defendants, the first and second defendants, to have leave to file and serve the amended defense and counterclaim filed herein on in the manner as shown in green as per the copy annexed hereto within 14 days from the date of the order. From the order, as in this order that I'm applying for. Save the cause and occasioned by the cause of an occasion by the reamended defense and counterclaim to be to the plaintiff in any event, the cause of this application be in the cause. So why do we invoke? These are the rules I'm relying on. So Order 3, Rule 5, because it's a time extension for the defendant to file the defense and counterclaim. Order 20, Rule 5, is because it's an amendment, which required leave of the court. Amendment of pleadings, I should say. Okay, the order is made on 5th of January. Now, no, sorry, I don't have the stamp here. Now, normally it would also, the order would also be sealed. You know that stamp? And there will be a date, and that's the date on which the order is sealed. But the effective date of that order is when it's granted, which is the 5th of January, 2021. Again, we have summons taken out by which firm? See that again, we know that the first and second defendants are the applicants for this interlocutory application. Okay, remember they're applying to amend the amended defense. Leave to file and serve. So originally they already have an amended defense and now they have a re-amended defense. So what color is that? Green, violet, I think. Can't remember. I think it's violet. Oh no, red, green. Okay, so they only have red and green on that. So this is what the summons look like. Now, okay, I'm not gonna do any more because I haven't redacted the later parts. But basically, that's that. Okay, so normally if they have something they want the court to allow them to do, in this instance, they want the court to allow that party to file and serve an yet amended defense. They normally would attach a draft of that document that they want the court permission to file and serve. Okay, so the court can see exactly what the defendants are trying to file and serve. Okay, makes sense, right? You can't approve something that you don't know enough about. So that's why. Okay, so again, that's a summons. It's requesting a hearing, essentially, right? You're just saying, yes, court, please give me a hearing, and notifying the other side at the same time, so everybody will be before the court. That's what a summons is. Okay, and essentially, you state what you're after. An affirmation, well, here it's an affirmation of service, but normally in some other instances, it would lay out all the evidence that is needed for that application. For example, if I'm applying to amend my defense and counterclaim, the defendant would make an affirmation in support of that application. And what do you think would be in that affirmation? You would lay out the reasons why you need the amendment, yes? Or why you need the time extension, right? Perhaps I have been stuck in Singapore because of COVID. I need quarantine, 14 days, I can't see anyone, I can't reach my legal rep or Zoom meeting or whatever, right? And as to the amendments necessary, they are necessary for the fair disposal because some events happened since the last time I filed my defense, and therefore I need to add the essential facts, etc. Right? You would lay out those facts and reasoning as evidence to support your application. Okay? So we all understand what an affirmation is for, right? It's evidence in support of any interlocutory applications. Any questions? Again, this is venturing beyond what you need to know, but just to show you an example so you know why I always hear summons and affirmation and what they are. Okay? No questions? Okay, from here onwards, we're going to learn at least, well, 2.5, I would say. We'll learn this topic, judgment in default, and another topic which we call summary judgment next class. How we can actually shorten the whole process as a plaintiff. Shorten the process of the whole or lifespan of the whole civil case. Okay, based on very strict guidelines and rationale. Judgment in default. When we're saying default, we're saying, okay, now put yourself in the shoes of a plaintiff on the plaintiff side. 告人嗰個, okay? Plaintiff side. Now, judgment in default is an application specifically only for the plaintiff. You are saying, or you're asking the court to grant judgment, a final judgment in favor of the plaintiff, yourself, because the defendant has been naughty in complying with timelines and rules. Now, we've been talking about 14 days, 14 days, 14 days, right? You've been hearing 14 days to return the acknowledgement of service. Yes? Yes? Right? So, then you ask, so what if the defendant don't? Right? 14 days, yes, we heard it. So that time limits prescribed within which a defendant has to respond to certain documents. The first one being the 14-day time limit to return the AS, acknowledgement of service. Okay? If the defendant fails to do so within the time limit, the plaintiff can apply for final judgment. That judgment we don't call it sort of final judgment, we call it judgment in default of, if it's the AS, judgment in default of AS. Okay, acknowledgement of service. So the plaintiff can apply for judgment to be entered against the defendant, which means in favor of the plaintiff. You can say it either way, right? In favor of the plaintiff means against the defendant. Correct? Yes, so sometimes they use interchangeably, but don't let it confuse you. It's purely the result of administration and time limits. Right? An administrative act by filing the required documents at the court registry. This default judgment or judgment in default, they are used interchangeably again. Default judgment or judgment in default, right? It's not a judgment on the merits of the case. Because what? Let's say the AS 14-day time limit. As soon as that 14 days has expired, the plaintiff is entitled, if the AS is not returned, the plaintiff is entitled to go to the court and apply, although it's an interlocutory application, it can deal with and KO, knock out the whole case, the whole defendant's case. Okay, so that's why we say it's purely administrative, because has the court looked at the rationale of the defendant's defense? The defendant hasn't had a chance yet, right? Purely because the defendant did not return the AS, acknowledgement of service, within 14-day time limit. That's what the plaintiff can do. That's why it's not a judgment on the merits of the case. It's purely on the defendant's failure on the procedures. Obtained without a trial, no appeal procedure. Okay, it's not called an appeal procedure, but you can apply to set it aside, and we'll look at it later. Okay, what can happen if, okay, missed the deadline, but the defendant wants to say, hey, I'm here, I'm just late a little bit, can you give me a chance? 俾次機會, right? So it's not called an appeal procedure. They have another application they can make to the court, but it's not entirely an appeal. We call it the defendant if the judgment has been granted, right? Again, we call it judgment in default of AS. If the failure is because failing the 14-day limit, the defendant, even after the judgment has been entered, the judgment in default has been entered, the defendant can apply to have that default judgment set aside. Remember, set aside means cancelled, right? It's equivalent to cancelled. But if the defendant doesn't apply to have the judgment set aside, that default judgment would be a proper judgment capable of being enforced, and that would wrap up the whole case. Okay? It's almost as if the defendant admits liability, but it's not. But just as well, the whole case is wrapped up. That's a sideline issue, but just to bring it to your notice, at any stage of the proceedings, a party can apply for legal aid. And the effect of an application of legal aid, you would actually, after you apply for legal aid, the firm would normally file something called Notice of Application of Legal Aid. File that with the court under this action, and it has the automatic effect to stay, meaning pause, the proceedings for 42 days upon filing a notice with the court. Okay, that notice is called Notice of Application of Legal Aid. Okay, you will see why we always have 28 days, 42 days. Most of the time they give days in multiples of weekdays, right? So multiples of 7. Okay, so you notice 28, 35, 42, etc. Okay, they're all multiples of 7 because for one way or reason they like to rotate it to the weeks. Okay, it also has the advantage sometimes if they want to go back to the same master or judge, etc. So they tend to give weeks. Now, this is still where we are, right? Up till now, we've just looked at pleadings, and there are actually two types of default judgments you can apply as a plaintiff. Remember, you're totally in the plaintiff's shoes now. Who's my girl to? Yes, Alice. Alice has issued the writ, file and serve the statement of claim. Okay, let's say it's been together. So if Hilda did not return or fail to file the AS within the 14-day period, what the plaintiff is applying for is judgment in default of acknowledgement of service. Okay. It's governed under Rules of High Court Order 13. The whole of Order 13 is about judgment in default of AS. Let's say, no, Hilda was not so slack in the beginning. She was okay in the beginning. She did file the AS. Okay? Let's say the court case is in Hong Kong. She did file the AS within the 14-day limit. The next thing she has to do is to file and serve the defense, right? That's the next pleading along the pipeline. Now, counting from the statement of claim, you have how many days? 28. Okay, 28. 28 from the statement of claim, you have 28 days within which to file the defense or defense and counterclaim. We don't care which one you file, you just have to file one. Okay, whichever is applicable in your case. Whether you have a counterclaim is up to Hilda, right? So as long as at least a defense is filed, it's okay. But if Hilda failed to file the defense within 28 days, so she did file this AS, but she didn't file the defense later on, right? It happens down the track. Failure to file the defense within timeline, judgment in default of defense. And this one is governed under Order 19. So there's already two hurdles of timeline that the defendant has to comply with. Failing which, default judgment, okay? Two possibilities of default judgment. Again, purely because of failure to comply with procedural rules or time limits. Not looked at the defense case yet. We're not looking at the merits of or relative strength or merits of the plaintiff and defense case. Okay, purely procedural. Now, do you think there are any implications of failing to file the reply within, 28 days? Do you think there is? Tricky question. Yes, raise your hand. No? Raise your hand. Good. Why? It's not mandatory, right? Of course, there's no implications. It's your choice. Okay, it's your choice. Now, in reality, plaintiff seems to like to file a reply anyway for practical reasons. Again, it's beyond your scope of the course manual. But because if you file a reply, first of all, if after the pleading stage close and you found that, yes, I need to file a reply after all, it's very hard to go back and try to apply to file a defense. But if you've already filed a reply, it's very hard to go back and ask the court's leave to file and serve a reply if you did not originally do so. However, if you found that, yes, there's something more I want to add or amend on the reply, it's much easier. It's much easier to apply for an amendment than to apply to file a defense after the close of pleadings. But that's for practical reasons. So also really like to stick a flag here. That's all. Okay. So even sometimes they put in they file and serve a very simple reply, they still tend to. Okay, but again, you're right, it's not mandatory. So no implications for the plaintiff, okay, for not filing a reply. Okay, so quite clear, right? Purely timelines. So, judgment in default of acknowledgement of service. Again, people tend to call it default judgment, but the proper name is judgment in default. I don't think they'll take any marks if you use default judgment. I tend to use default judgment. But so long as you know which one it is for. So Order 13 is for failure to file AS. This you've heard many times. Okay, plaintiff served the writ on defendant. Defendant must return AS within 14 days. Indicating an intention to defend within the prescribed time limit, within 14 days of being served the writ. Okay, the day of the service is included within the 14-day period as day 1. In the AS, the defendant has to indicate whether he will be contesting the claim. I don't think we need to go through the AS sample, right? We went through that the other night. Repeating the obvious and repeating and repeating. Okay. If the claim, on the AS, if the claim is for a liquidated amount and the defendant indicated not intending to contest or defend the action, the defendant can apply for a stay of execution or by writ of FIFA by ticking the appropriate box on the Form 14. This will result in an automatic stay of execution for 14 days. Okay, so you're pausing, you're asking, no, I don't want to fight, so let's not incur any further cost. I'm telling the plaintiff now, I'm not intending to fight the case. I'm not contesting the case. Okay, so by ticking the appropriate box on the Form 14, there would be a stay of execution. Remember, stay is like a pause, it's like a freeze. Okay, so during that 14 days, the original 14 days is almost automatic, as long as you tick the proper box in the AS, on the AS. During that 14 days granted stay, the defendant can then apply for a permanent stay of execution, and arrangements can be made on how to pay, etc. Okay. Again, if defendant just simply do not file the AS, the plaintiff can apply to enter a judgment in default of AS under Order 13. The application process. Application by summons, supported by affirmation. If the claim is, okay, so again, you see the word summons and affirmation. Why do we say supported? Because affirmation is evidence. Okay, so summons is the official document supported by affirmation as evidence. If claim is for liquidated amount, an ascertainable amount, the plaintiff can apply for final judgment. If the claim is for an unliquidated amount, which means it has to be assessed or determined by the court, the plaintiff can apply for final judgment on liability. But as to the quantum, it would have to be assessed by the court. Okay. As to Order 19, very similar. After defendant filed the AS, the defendant has to file the defense or defense and counterclaim. For a specifically endorsed writ with the SOC, the defendant must file and serve the defense within 28 days after the last day permitted for filing the AS. Notice the last date being the deadline for filing the AS, not the actual date the AS has been filed. For generally endorsed writ with no SOC, then you count 28 days from when the SOC was actually served. Remember, as I reminded you last time, is the date it's been served on the party, not the date filed with court. right? For obvious reasons. Remember I said, okay, if you drag on for another 5 days without serving on the party, it would be unfair. Okay, if time limit has expired for filing the defense, the plaintiff can apply to enter judgment in default of defense, and this time it would be under Order 19. Also, same deal. Again, summons supported by affirmation. If claim is for a liquidated amount, same thing, plaintiff can apply for final judgment. And because nothing else has to be determined, that's the end. If claim is for unliquidated amount, again, final judgment entered on liability, but amount or quantum will be assessed by the court. Okay, the only extra step for Order 19 judgment in default of defense is that assuming you only, now why would you wait till, go back here. Now under normal circumstances, if the plaintiff is applying for Order 19, it's because the defendant has filed the AS, right? Otherwise, you would have knocked him out here at this stage. Agree? So if you proceed to here and only apply for judgment in default of defense, it means this was filed. And that the defendant on this AS indicate they want to contest. Agree? Otherwise, you would have done the Form 16, Form 16C, whatever. Right? You would have entered judgment based on admission. So the only other thing different is that if the defendant has given notice of intention to defend, plaintiff must give the defendant a notice of intention to enter judgment in writing before entering judgment. Okay, so if we proceed until Order 19 stage, that means the defendant would have indicated the intention to contest the proceedings against your claim. So this additional piece of document you have to serve on the defendant. It's like tapping them on the shoulder. Hey, I notice you've indicated you want to contest against my claim. So I'm giving you a final tap on the shoulder to tell you, hey, you haven't filed your defense. If you don't do anything, I will enter judgment against you. Okay, that's what this document is for. Notice of intention to enter judgment. Okay. Now, defendant has given notice of intention to defend. What is that? That's really the same as AS. It's the same thing. Okay, it just means an AS on which the defendant has said, yes, I want to contest the proceedings. That notice of intention to enter judgment, you must serve on the defendant at least 2 days before entering judgment. But the plaintiff can serve the notice at any time after the notice of intention to defend has been filed. Okay, so after the AS, they can straight away file this notice. The purpose is to give defendant a warning of defendant's default in not filing the defense. Okay, final tap on the shoulder as a final warning. Okay. Now there may be other reasons. To let you go. Now there may be other reasons why in real life, okay, as you learn it, you should just know that if no AS within 14 days, go to Order 13, knock them out. If they file AS and not file defense onwards, knock them out with Order 19. In reality, there can be reasons why they didn't file this, but you wait until here. Okay. I don't want to confuse the whole class. If you're in the industry, you want to ask more, you can come and ask me. But for exam purposes, all you have to know is that for AS, failure to file AS, order 13, failure to file defense, order 19. Okay, in that order. Okay, otherwise, too much exceptions. Okay, then just that would confuse you too much. Okay. Should I go for here? It's a bit early, that's fine. Right, I'll just talk about the rationale. I'll go for the rationale about setting aside. Okay, now I'll go through in detail next time. Now, setting aside judgments, interlocutory judgments. Now, today we're talking about judgment in default of either AS or defense. So, while Alice, Sue, Hilda, Alice did all this SOC, read, served, etc. Hilda didn't respond within time limit. So Alice entered judgment against Hilda based on such default, breach of the timeline requirements. Hilda then come to her senses. Hang on. What is this? 1 million claim against me? Oh my. I didn't even know judgment has been entered. Now, there may be proper reasons for why Hilda did not respond within time, or there may not be. Now, whether we will then talk about regular judgments and irregular judgments. As the name suggests, regular judgments are judgments that the plaintiff got or obtained, as the proper wording. Plaintiff obtained having done everything properly. Okay, so Alice did her service properly on Hilda. Hilda has simply been slack and lazy and naughty. Okay? Based on that, based on Alice having fulfilled as plaintiff everything she is required to do, the judgment she obtained would be called regular judgment. However, let's say when Alice served Hilda, she served Hilda by postal rule. Unbeknown to her, it wasn't intentional on her part. Hilda was overseas and out of jurisdiction. Remember, by postal rule, one of the requirements is that the defendant must have been within jurisdiction at the time of service. Well, Hilda was not. Because of COVID, she was visiting friends in Canada, and because of the COVID and quarantine, she didn't want to bother to come back so soon, so she stayed there longer. She hasn't been here in Hong Kong for 3 months. She had no idea that there's been such proceedings. When she came back, 3 months is gone. Okay, so meanwhile, Alice has entered judgment against her. Now, because even though it's not intentional on Alice's part, she breached the rules, right? Because Hilda wasn't in Hong Kong. Agree? So that in breach of the rules, judgment entered or obtained in breach of procedural rules on the plaintiff's part would be irregular. Okay, so the only difference between regular and irregular is whether the plaintiff did everything and complied with all the rules she is required to comply with. Okay, if all rules have been complied with, nothing in breach, the judgment obtained, regular. If there's some breach of rules, judgment obtained would be irregular. As simple as that. Everybody got that? Okay? So guess what? If, without looking at all that sort of stuff first, don't worry about that. Without looking at the board, well, Hilda now, wakey, she realized that judgment has been entered against her. She received some enforcement notice and things like that, so she knew there had been a claim against her. So what would she want to do? She would want to apply to set aside the judgment. Now, guess what? Now, based on what I've just told you about regular judgments and irregular judgments, which do you think is easier for Hilda to set aside? Irregular, yes, very good, right? That's why don't just think about yes, regular, irregular definition. Think about the rationale. It's much easier for you to realize yes, irregular judgment should be easier to set aside, right? Because there has been breach by the plaintiff in the beginning. Yes? Okay? So you got it. The process to apply to set aside is very similar for regular judgment and irregular judgment. Guess what? Summons and affirmation, right? You see that all the time. Okay? Summons, affirmation, summons, affirmation. The only difference is how easy and by what standard or what factors the court would think about upon that application. Okay, deciding, because you will see everything is at the court's discretion. Okay, most interlocutory application, this and that. Yes, the court will consider all factors, this and that. Ultimately, okay, so irregular judgments much easier to set aside. And to set aside default judgment or judgment in default of AS, guess what? Also under Order 13, right? The original application for judgment in default of AS is Order 13. The application to set aside that default judgment is also Order 13, except it's Rule 9. To set aside judgment in default of defense would be under Order 19, also correspondingly is Rule 9. General discretion of the court, so no automatic entitlement, theoretically, to avoid potential injustice caused by a judgment in default. It's a fine balance between the observation of procedural rules and the deprivation of a party of adjudication on the merits of the case. Okay, because bearing in mind that there has been no assessment of the merits of either the plaintiff or the defendant's case yet. Okay, so that's the balance. Okay, so Hugo Boss trademark and Britain Boss. Okay, I think we're good on time, and I'm happy to give you, it's a bit early, but yes, I see nodding heads. Okay, I'll stop here tonight, because otherwise we go into the nitty-gritty bits about how it can be improper, how it can be regular and not regular, and attaching conditions, right? So we'll go to that next time. Meanwhile, I'll stay for another 10-15 minutes if you have any questions.